Okay, hello. Andito na naman si Lolo Ray para na naman sa isa na namang edisyon ng sa madaling salita or in layman's terms kung saan magbabasa-basa tayo ng mga batas, ng mga codal provisions at susubukan lang natin paliwanag siguro kung may kaya man tayong paliwanag. Sama-sama natin suriin para mabigyan tayo ng idea sa mga batas. Okay, itong edisyon na ito ay ang criminal procedure na. Natapos na natin sa mga nagdaang live natin yung nabasahin yung civil procedure pagkahaba-haba, yung special proceedings pagkahaba-haba. Ngayon naman, dito naman tayo sa criminal procedure. Okay, nagsisimula po ang criminal procedure sa mga mayroong taglay na rules of court sa Rule 110. Okay, prosecution of offenses, Rule 110. Section 1. Institution of criminal actions. Criminal actions shall be instituted as follows. Letter A. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112. Mamaya tutungo tayo sa Rule 112. By filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. Letter B. For all other purposes by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts or the complaint with the office of the prosecutor. So pwede ka pala magsampa ng complaint kung nasa jurisdiction ito ng MTC, diretso ka sa MTC, or sabi nila sa office of the prosecutor. Yung una, sinasabi ron yung mag-file ka sa police ng complaint. Yung letter B naman, mag-file ka sa korte or sa prosecutor. In Manila daw and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. The institution of the criminal action shall interrupt the running period of prescription of the offense charged unless otherwise provided in special laws. Okay, mga special laws po yan, yung mga bagong batas ng mga RA something, RA, ganyan. Okay. Pero ang ibig lang sabihin noon, kapag nag-institute ka na ng action, may stop na muna yung period ng prescription. Kasi po bawat krimen ay may prescription. Kunwari lamang, example, ang rape, ang prescription niya kunwari ay 12 years. So, yung running nung prescriptive period ng 12 years, ibig sabihin po nun, after 12 years, hindi mo na, kunwari lang to ha, after 12 years, hindi mo na maaaring isampa yung kaso ng rape pag lumipas na yon. Simula nung huling mangyari sa yon. Ganun po yun. So, may stop daw nun yung period, yung pagtakbo ng period of prescription. Section 2, the complaint or information. The complaint or information shall be in writing in the name of the people of the Philippines and against all the persons who appear to be responsible for the offense involved. So ano nga ba yung complaint? A complaint is a sinumpaan na written statement charging a person with an offense subscribed by the offended party and peace officer or other public officer in charge with the enforcement of the law violated. So ito yung mga salaysay ng pagrereklamo na isinasampa sa pulis. Okay. Section 4, ano naman yung information? An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Ito yung naman yung mga reklamong kapag yung piskal, kunwari, nakita niya, nakarapat-dapat isampa sa korte yung kaso, magfa-file siya ng information, ipa-file niya na sa court, sasampahan niya na ng kaso sa korte yung tao. Section 5, who must prosecute criminal actions? Sabi rito, as last updated by OCA Circular 39-02-2002. So basahin lang muna natin to, hindi ko na sure kung meron pang ibang mga batas. Kung may matuklasan akong pagbabago, ay ilalagay ko po yung link dito. So, all criminal actions, sabi niya, either commenced by complaint or by information shall be prosecuted under the direction and control of the public prosecutor. In case of heavy work schedule of the public prosecutor o yung piskal, or in the event of lack of public prosecutors, the private prosecutor may be authorized in writing by the Chief of the Prosecution Office or the Regional State Prosecutor to prosecute the case subject to the approval of the court. So, kung ikaw daw ay sumumpa ka ng salaysay sa pulis ng pagrereklamo, kung mapapansin ninyo, itong mga pulis na ito ay dadalhin niya sa office ng piskal ito para magsampa ka ng kasong kriminal laban sa isang tao. O kung dumirekta ka man sa piskal, ganun din. Siya pa rin ang magbubusisi noon kung karapat dapat bang isampa. Okay, nasa na ako. Once so authorized to prosecute the criminal action, the private prosecutor, wait lang ituloy ko lang. Kunwari meron kang private lawyer na gusto mong mag-prosecute nung kaso mo. Gusto mong siya yung magdiin doon sa kalaban mo. Kailangan niyang mag-secure muna ng authority to prosecute sa office ng piskal o ng prosecutor. Basahin natin ulit. Once so authorized to prosecute the criminal action, the private prosecutor, yun nga yung sinasabi nating private lawyer mo na nagkaroon ng authority sa prosecutor, shall continue to prosecute the case up to the end of the trial even in the absence of a public prosecutor unless the authority is revoked or otherwise withdrawn. However, in municipal trial courts or municipal circuit trial courts, when the prosecutor assigned thereto or to the case is not available, the offended party, any peace officer or public officer charged with the enforcement of the law violated may prosecute the case. This authority shall cease upon actual intervention of the prosecutor or upon elevation of the case to the regional trial court. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. Pero hindi na masyadong ginagamit ito. Ang mga babae ngayon madalas ginagamit 9262 o yung anti-vowsy law kasi mas may pangil yun sa batas. Pero ang ibig lang sabihin nito, kailangan yung crimes ng adultery at concubinage ay ipoprosecute lamang kapag merong reklamo at ang nagreklamo lamang ay yung asawa. The offended party cannot institute criminal prosecution without including the guilty parties if both are alive, nor in any case if the offended party has consented to the offense or pardoned the offenders. Yung offenses naman daw of seduction, abduction, and acts of lasciviousness shall not be prosecuted except upon complaint filed by the offended party or her parents, grandparents, or guardian, nor in any case if the offender has been expressly pardoned by any of them. If the offended party dies or becomes incapacitated before she can file a complaint and she has no known parents, grandparents, or guardian, the state shall initiate the criminal action in her behalf. The offended party, even if a minor, has the right to initiate the prosecution of the offenses of seduction, abduction, and acts of lasciviousness independently of her parents, grandparents, or guardian unless she is incompetent or incapable of doing so. So kahit minor daw, pwede siyang mag-initiate ng kaso na ito unless incompetent siya o yung may karamdaman sa pag-iisip, yung mga ganyan. Where the offended party who is a minor fails to file the complaint, her parents, grandparents, or guardian may file the same. The right to file the action granted to parents, grandparents, or guardian shall be exclusive of all other persons and shall be exercised successively in the order herein provided, except as stated in the preceding paragraph. No criminal action for defamation which consists in the imputation of any of the offenses mentioned above shall be brought except at the instance of and upon complaint filed by the offended party. The prosecution for violation of special laws shall be governed by the provisions thereof. Yung mga sinasabi-sabi natin na RARA, mayroong bagong batas na inilatag ang Kongreso. Kunwari, may bago ng batas, yung 9262, para parusahan yung mga nagtataksil na mga asawa. Usually, yung provision na ng bagong batas na yun ang mangungusap. Kasi po, karamihan na nakalagay pa rito sa Crim Pro, yung mga felonies o yung mga krimen na dinefine sa revised penal code. Pero maraming batas po ang nasusupersede na. Okay, kunwari ang example natin may child protection laws ah, sa revised penal code kunwari, na supersede na ito ng RA 7610 na mas nagpoprotekta o mas komprehensibo at mas mataas ang penalty na ibinibigay sa mga krimen laban sa mga bata. Parang ganon. Yun po ang example. No? Section 6, sufficiency of complaint or information. A complaint or information, if it is sufficient, sapat raw ito, if it states the name of the accused, the designation of the offense given by the statute, the acts or omissions complained of as constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and ika-anim, the place where the offense was committed. Nakalagay po yan dun sa information na ipinapasa ng piskal na ipinafile niya sa korte para kasuhan ka na. When an offense is committed by more than one person, all of them shall be included in the complaint or information. Section 7, Rule 110 pa rin. The name of the accused. The complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been or is known. If his name cannot be ascertained, he must be described under a fictitious name with a statement that his true name is unknown. So kahit di alam yung pangalan mo, pare, tawag sa'yo Boknoy, nako, alias Boknoy, nakakasuhan ka pa rin. Section 8, designation of the offense. The complaint or information shall state the designation of the offense given by the statute o yung batas given by the batas, aver the acts or omissions o i-state yung acts or omissions constituting the offense and specify its qualifying and aggravating circumstances. Ibig sabihin nun, kung ano ba yung nagka-qualify sa'yo para dun sa isang krimen mo na lumala. Example ng aggravating circumstances, yung kasambahay ka na may access ka sa mga pribadong paggagamit ng iyong amo tapos ninakawan mo. Hindi lang yun ordinaryong theft, nagiging aggravated na siya, nagiging qualified theft. Ang qualifying circumstance yung pagiging kasambahay mo, yung trust and confidence na binibigay sa'yo. So if there is no designation of the offense, reference shall be made to the section or subsection of the statute punishing it. Section 9, cause of the accusation. The acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language and not necessarily in the language used in the statute, but in terms sufficient to enable a person of common understanding to know what offense is being charged as well as its qualifying and aggravating circumstances and for the court to pronounce judgment. So, kailangan maipaliwanag na maayos sa tao yung ano man yung ginawa niya o hindi niya ginawa na naging opensa. Kailangan ipaliwanag sa kanya yun. Maintindihan ng akusado. Section 10, place of commission of the offense. The complaint or information is sufficient if it can be understood o maiintindihan mong maigi from its allegations that the offense was committed or some of the essential ingredients occurred at some place within the jurisdiction of the court, unless a particular place where it was committed constitutes an essential element of the offense or is necessary for its identification. Tandaan kasi natin, bawat krimen may elemento. Section 11, date of commission of the offense. It is not necessary to state in the complaint or information the precise date the offense was committed except when it is a material ingredient of the offense. So kung makakita kayo ng mga krimen na pinafile sa Office of the Prosecutor, hindi naman sakto yung oras o yung date unless yung date nga na yun material doon sa umahalaga na ingredient ng offense, katulad ng paglabag mo kunwari sa bouncing checks law, tumalbog yung cheque, kailan, material yung date, mahalaga yung date. Pero kung hindi naman ganun yung kaso, pwedeng hindi naman sakto yung nakasaad sa information. The offense may be alleged to have been committed on a date as near as possible to the actual date of its commission. Kaya nakalagay po sa mga information kadalasan pag hindi naman material yung date on or before ganito, ganyan-ganyan, naganap ang ganito. Yun ang nakalagay sa information. Section 12, name of the offended party. The complaint or information must state the name and surname of the person against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been or is known. If there is no better way of identifying him, he must be described under a fictitious name. So letter A, offenses against property. If the name of the offended party is unknown, the property must be described with such particularity as to properly identify the offense charged. Letter B. If the true name of the person against whom or against whose property the offense was committed is thereafter disclosed o napag-alaman na or ascertained, the court must cause the true name to be inserted in the complaint or information in the record. Letter C. If the offended party is a juridical person, it is sufficient to state its name. Juridical person po, yan yung mga korporasyon, yung may sariling legal personality. Didiscuss natin yan minsan pag dumating tayo sa civil code. So if the offended party, sabi niya ulit, is a juridical person, it is sufficient to state its name or any name or designation by which it is known or by which it may be identified, without need of averring that it is a juridical person or that it is organized in accordance with the law. Section 13. Duplicity of the offense. A complaint or information must charge but one offense, except when the law prescribes a single punishment for various offenses. Sabi nga rito, sa isang pagrereklamo o impormasyon, kailangan iisa lang ang offense na nakalagay, maliban na lamang kung mayroong batas na nagpe-prescribe ng isa lamang na punishment para sa iba-ibang pagkakamali o iba-ibang krimen. Section 14. Amendment or substitution. Yun daw, complaint or information may be amended in form or in substance without leave of court at any time before the accused enters his plea. Bago mag-enter ng plea, whether guilty or not, yung isang tao, anytime na mangyari yun, pwedeng mag-amended complaint yung piskal o yung private prosecutor. After the plea and during the trial, a formal amendment may only be made with leave of court and when it can be done without causing prejudice to the rights. Ang ibig lamang sabihin nito, kung mag-aamenda ka ng iyong impormasyon matapos ang plea, ano bang tawag dyan, arraignment, after ng pag-enter ng plea, whether guilty or not, nung akusado, kung after noon, doon ka magsusumite ng iyong amendment, kailangan mo rin mag-file nung abogado ng motion for leave of court. At kung papayagan niya ba ito. However, any amendment before plea which downgrades the nature of the offense charged in or excludes any accused from the complaint or information can be made only upon motion by the prosecutor with notice to the offended party and with leave of court. The court shall state its reasons in resolving the motion, and copies of its order shall be furnished all parties, especially the offended party. So yun po yun, pag-amyenda. Kasi nga naman, pagka inamyendahan mo yun nakalagay sa impormasyon o sa iyong complaint, di ba? Di malaki ang epekto nun, whether nagtanggal ka ng isang akusado roon o na-downgrade yung offense na sinacharge mo sa kanya. If it appears at any time before judgment that a mistake has been made in charging the proper offense, the court shall dismiss the original complaint or information upon the filing of a new one charging the proper offense in accordance with Section 19, Rule 119, provided the accused shall not be placed in double jeopardy. Kasi iba nakaangkla sa konstitusyon yan, yung double jeopardy. The court may require the witness to give bail for their appearance at the trial. So para temporarily hindi ka muna makulong, piyansa ka muna kung bailable ang kaso mo. Section 15, place where action is to be instituted. Letter A, subject to existing laws, the criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed or where any of its essential ingredients occurred. Letter B, Where an offense is committed in a train, aircraft, or other public or private vehicle while in the course of its trip, the criminal action shall be instituted and tried in the court of any, kahit saan sa mga nadaanan niya, municipality or territory where such train, aircraft, or other vehicle passed during its trip, including the place of its departure and arrival. Letter C. Where an offense is committed on board a vessel in the course of its voyage, the criminal action shall be instituted and tried in the court of the first port of entry or of any municipal or territory where the vessel passed during such voyage. So lahat ng dinaanan niya o yung unang port of entry niya, 'di ba? Subject to the generally accepted principles of international law. Letter D. Crimes committed outside the Philippines but punishable under Article 2 of the Revised Penal Code shall be cognizable by the court where the criminal action is filed. Section 16. Intervention of the offended party in criminal action. Where the civil action for recovery of civil liability is instituted in the criminal action pursuant to Rule 111, the offended party may intervene by counsel in the prosecution of the offense. Kasi lagi nating tatandaan, halos lahat, bawat criminal bawat criminal act may katumbas na civil liability. Daños perjuicios in layman's term. Damages, yan. Rule 111, prosecution of civil action. Ito yung last na pinag-usapan natin. Ito yung direktang katuloy. Section 1, institution of criminal and civil actions. Teka lang, wait lang. Ayan, medyo mainit lang. Nilakas natin ang fan. Institution of criminal and civil actions. Letter A. When criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserves the right to institute it separately, or institutes the civil action prior to the criminal action. Okay? So, usually kasi kasamang binibista yan pagka may criminal action, may kaakibat na civil liability, may pinag-uutos doon sa desisyon ng korte kung ikaw ay nahatulan na guilty na magbabayad ka rin ng ganitong halaga. Pero pwede raw yan i-waive, sabi nung at idinggin separately. Okay? The reservation of the right to institute separately, the civil action shall be made before the prosecution starts presenting its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. So, pwede yung isang biktima, pwede niyang i-reserve yung kanyang right to institute a separate civil action bago lamang magpresenta ng ebidensya yung prosecution. In layman's terms, sa atin, alam natin yan, bago siya magpakita ng witness, alam mo yun, yung maganap na yung actual na nagaganap sa korte. Yun. Bago mangyari yon, kailangan makapag-reserve ka na ng right to institute separately the civil action kung gusto mo lamang. When the offended party seeks to enforce civil liability against the accused by way of moral, nominal, temperate, or exemplary damages without specifying the amount thereof in the complaint or information, the filing fees thereof shall constitute a first lien or claim on the judgment awarding such damages. When the amount of damages other than actual, kasi may iba-ibang uri ng damages, other than actual is specified in the complaint or information, the corresponding filing fees shall be paid by the offended party upon the filing thereof in court. Except as otherwise provided in these rules, no filing fees shall be required for actual damages. No counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case. But any cause of action which could have been the subject thereof may be litigated in a separate civil action. So, kunwari, may iba kang civil na yung akusado, meron siyang ibang civil rights na gusto niyang kunin. against doon sa nagrereklamo sa kanya, hindi siya pwede mag-file ng counterclaim, cross-claim, or third-party complaint kagaya sa ordinary civil procedure. Pwede lang siya mag-file ng sarili niya. Another separate civil action yun. Walang kinalaman doon sa litigasyon o doon sa pagdinig, doon sa kaso laban sa akusadong yun, sa krimen na di umano ay ginawa niya. Letter B. The criminal action for violation of Batas Pambansa bilang 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. Upon filing of the aforesaid joint criminal and civil actions, the offended party shall pay in full the filing fees based on the amount of the check involved, which shall be considered as the actual damages claimed. Where the complaint or information also seeks to recover liquidated, moral, nominal, temperate, or exemplary damages, yan yung mga nabanggit nating uri ng damages, the offended party shall pay additional filing fees based on the amounts alleged therein. Kasi nga, sabi natin kanina, kung actual damages, di mo na kailangan magbayad pa ng karagdagang filing fee. If the amounts are not so alleged, but any of these damages are subsequently awarded by the court, the filing fees based on the amount awarded shall constitute a first lien or claim, ibig sabihin ng lien, claim, a first lien on the judgment. Where the civil action has been filed separately and trial thereof has not yet commenced, it may be consolidated with the criminal action upon application with the court trying the latter case. If the application is granted, the trial of both actions shall proceed in accordance with Section 2 of this rule governing consolidation of the civil and criminal actions. Section 2. When separate civil action is suspended. After the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. If the criminal action is filed after the said civil action has already been instituted, the latter shall be suspended in whatever stage it may be found before judgment on the merits. The suspension shall last until final judgment is rendered in the criminal action. Nevertheless, before judgment on the merits is rendered in the civil action, the same may, upon motion of the offended party, be consolidated with the criminal action in the court trying the criminal action. In case of consolidation, the evidence already adduced in the civil action shall be deemed automatically reproduced in the criminal action without prejudice to the right of the prosecution to cross-examine the witnesses presented by the offended party in the criminal case and of the parties to present additional evidence. The consolidated criminal and civil actions shall be tried and decided jointly. During the pendency of the criminal action, the running of the period of prescription of the civil action which cannot be instituted separately or whose proceeding has been suspended shall be told. Tigil muna. The extinction of the penal action, ulitin natin. The extinction of the penal action does not carry with it extinction of the civil action. However, the civil action based on delict shall be deemed extinguished if there is a finding in the final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist. Section 3. When civil action may be proceeded independently. May kasong criminal ka pero yung civil action mo raw may be proceeded independently. In the case provided for in Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines, the independent civil action may be brought by the offended party. It shall proceed independently of the criminal action and shall require only a preponderance of evidence. In no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. Yung offended party, hindi naman siya pwedeng mag-recover ng damages twice sa iisang act lang o sa iisang cause of action lang niya nung criminal action. Parang laban nun, cause of action civil eh. Sa isang criminal action, gano'n na lang. Section 4. Effect of death on civil actions. Yung kamatayan raw or yung death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from the delict. However, the independent civil action instituted under Section 3 of this rule, or which thereafter is instituted to enforce liability arising from other sources of obligation, may be continued against the estate o dun sa pag-aari or the legal representative of the accused after proper substitution or against said estate as the case may be. So, ang hirap gumawa ng krimen, pati yung pag-aari mo kung namatay ka na, pwedeng habulin para magbayad ng danyos. The heirs of the accused may be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian ad litem for the minor heirs. The court shall forthwith order said legal representatives or representative to appear and be substituted within a period of 30 days from notice. A final judgment entered in favor of the offended party shall be enforced in the manner especially provided in these rules for prosecuting claims against the estate of the deceased na mayapang akusado. If the accused dies before arraignment, the case shall be dismissed without prejudice to any civil action the offended party may file against the estate of the deceased. So kung namatay ang isang akusado bago ang arraignment, bago siya makapagsabing guilty or not guilty, ano yung ipapasok mong plea? Madidismiss na kaagad yung action laban sa kanya without prejudice o without pagbabawal na mag-file pa ulit ng separate civil action yung nadehado o yung naagrabyado laban doon sa estate ng deceased. Laban doon sa naiwang ari-arian nung namayapang akusado. Section 5. Judgment in civil action, not a bar. A final judgment rendered in a civil action absolving the defendant from civil liability is not a bar o hindi ito harang to a criminal action against the defendant for the same act or omission subject of the civil action. Section 6. Suspension by reason of prejudicial question. A petition for suspension of the criminal action based upon the pendency of a prejudicial question in a civil action may be filed in the office of the prosecutor or the court conducting the preliminary investigation. When the criminal action has been filed in court for trial, the petition to suspend shall be filed in the same criminal action at any time before the prosecution rests. So kung gusto mo mag-file na suspension by reason of prejudicial question, if ina-file ito ng abogado bago magpahinga yung prosecution, ibig sabihin nun, bago siya matapos na ipresenta lahat ng ebidensya niya sa korte. At any time, bago niya ibigay yung turn, kung baga in layman's term, bago niya ibigay yung turn doon sa defense, na defense naman yung magpipresenta ng kanila ebidensya, bago matapos yung prosecution. Section 7. Elements of prejudicial question. Ano ba yung prejudicial question na pinag-uusapan natin na yan? The elements of a prejudicial question are: letter A. The previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. And letter B. The resolution of such issue determines whether or not the criminal action may proceed. Yun. May nauna ng civil case. Yung determinasyon na yun ay talagang konektado rito sa criminal action na to. Sabi, letter A, yung civil action na existing na, yung pagkakaresolba nito ay pwedeng magdikta kung karapat-dapat bang ituloy itong isa pang nagbabadyang criminal action o hindi. Rule 112. Punta na tayo. Medyo mahaba rin pala ito ha. Preliminary investigation. Ito, as amended by Administrative Matter number 05-8-26-SC. Ano ba itong preliminary investigation? Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Ito yung ginagawa kadalasan ng mga piskal na titignan nila, iniimbestigahan nila, pinapatawag yung pulis, pinapatawag yung mga partidos, pinagtatagpo-tagpo kayo sa fiscal's office, whether or not inaalam nila, meron bang probable cause? Malamang ba ginawa niya itong krimen na ito? O meron bang krimen talagang naganap? Except as provided in Section 6 of this rule, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine. So bago raw mag-file ng complaint, dapat na preliminary investigation muna. Kaya pinapatawag sa piskal yan eh. Section 2. Sino ba yung mga officers authorized to conduct preliminary investigations? Ito sila. Letter A, provincial or city prosecutors and their assistants. Letter B, national and regional state prosecutors. And letter C, other officers as may be authorized by law. Their authority to conduct preliminary investigations shall include all crimes cognizable or kinikilala by the proper court in their respective territorial jurisdictions. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. Letter A. The complaint shall state the address of the respondent and shall be accompanied by affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies for the official file. The affidavits shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath, or in their absence or unavailability, before a notary public, each of whom must certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. Letter B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and document. Kaya sakit-sapit nito una na to. Yan. The respondent shall have the right to examine the evidence submitted by the complainant, which may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and these shall be made available for examination or copying by the respondent at his expense. Objects as evidence need not be furnished a party but shall be made available for examination, copying, or photographing at the expense of the requesting party. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavit and that of his witnesses and other supporting documents relied upon for his defense. Pinagtatanggol niya yung sarili niya sa piskal pa lang, sa prosecutor pa lang to ha. The counter affidavit shall be subscribed and sworn to and certified as provided in paragraph A of this section, with copies thereof furnished by him to the complainant. The respondent shall not be allowed to file a motion to dismiss in lieu of a counter affidavit. So bawal siya mag-file ng motion to dismiss doon sa piskal in lieu of a counter affidavit. If the respondent cannot be subpoenaed, ito letter D. If the respondent cannot be subpoenaed, or if subpoenaed pero does not submit counter affidavits within 10-day period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. Yun ang rules. Letter E. The investigating officer may set a hearing if there are such facts and issues to be clarified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. Sa korte kasi ginagawa yung cross-examine na yan. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from submission of the counter affidavits and other documents or from the expiration of the period for their submission. It shall be terminated within 5 days. Letter F. Within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. Kapag walang sapat na basihan, walang probable cause, i-dismiss ang kaso mo sa prosecutor's level pa lang. Hindi na yan aakyat ng korte. Kung sa tingin naman ng piskal, may sufficient ground o may probable cause na may krimen na ginawa at yung akusadong tinuturo ang gumawa, pa-file niya na yan sa korte. Doon mo masasabing may kaso na ako sa korte. Pwede ka na magpiyansa. Section 4, Resolution of Investigating Prosecutor and its review. If the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he, or as shown by the record, an authorized officer has personally examined the complainant and his witnesses. Tapos, dagdag natin, that there is reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof. That the accused was informed of the complaint and of the evidence submitted against him. And that he was given an opportunity to submit controverting evidence. Yun yung nakalagay sa resolution ng piskal. Kung wala yung mga yon, otherwise, he shall recommend the dismissal of the complaint. Within 5 days from the resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or to the ombudsman or his deputy in cases of offenses cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. They shall act on the resolution within 10 days from their receipt thereof and shall immediately inform the parties of such action. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or the ombudsman or his deputy. Where the investigating prosecutor recommends the dismissal of the complaint but his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy on the ground that a probable cause exists, the latter may, by himself, file the information against the respondent or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. So nasusunod pa rin talaga, mas mataas, ano? If upon petition by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief state prosecutor, he shall direct the prosecutor concerned either to file the corresponding information without conducting another preliminary investigation or to dismiss or move for dismissal of the complaint or information with notice to the parties. The same rules shall apply in preliminary investigations conducted by the officers of the Office of the Ombudsman. Kasi po ang last resort dito, pagka kino-contest mo yung ruling ng isang piskal, yung mas nakakataas sa kanyang piskal, di ko lang alam kung provincial ba or depende, tapos pwede kang pumunta sa DOJ. Yun na nga, kaya sinabi parang, kumbaga ang Supreme Court, pagka nasa fiscal's level pa lang, prosecutor's level pa lang ang kaso, hindi pa naisampa sa korte, yung DOJ secretary, siya may last say. Kung abot dun. Section 5, when warrant of arrest may issue. O, sabi rito, ang nag-i-issue ng warrant of arrest ay ang Regional Trial Court. Regional Trial Court within 10 days from the filing of the complaint or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. So kung nagkamali si piskal, nakita ng judge, wala namang probable cause, pwede na dismiss agad. If he finds probable cause, he shall issue a warrant of arrest or a commitment order, ipapakulong. when the complaint or information was filed pursuant to Section 6 of this rule. In case of doubt on the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. Pero birang mangyari yan. Kadalasan, pag final mo na sa court, isi-set na kaagad nila yan for arraignment. And tuloy-tuloy na yung kaso dyan. By the municipal trial court, pwede rin daw mag-issue ang municipal trial court. When required pursuant to the second paragraph of Section 1 of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court shall be conducted by the prosecutor. Tama ba? Ayan. The procedure for the issuance of a warrant of arrest by the judge shall be governed by the paragraph A of this section. Okay? Ayun. When warrant of arrest ay hindi necessary, not necessary. A warrant of arrest shall not issue if the accused is already under detention pursuant to a warrant issued by the municipal trial court in accordance with the paragraph B of this section, or if the complaint or information was filed pursuant to Section 6 of this rule, or is for an offense penalized by fine only. The court shall then proceed in the exercise of its original jurisdiction. Section 6. When accused lawfully arrested without warrant. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with the existing rules. Ini-inquest mo dapat agad yung isang inaresto ng walang warrant. Kailan ba usually na-aresto yung ng walang warrant? Kapag sa presence, actual presence ng isang police officer, nakita niya na may ginagawang krimen or is about to commit a crime. Kunwari, hindi pa nga nasusunog yung bahay pero nagsisindi na siya ng pasabog doon sa harap ng bahay, maggagawa siya ng arson. O may public knowledge na talagang ginawa nito. Hindi public knowledge, may personal knowledge ang isang alagad ng batas. Pwede niyang hulihin yon at i-inquest. Sabi niya dito, yun, the complaint may be filed by the offended party or by a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Kaya nagpapasa ng affidavit yung mga polis hanggang umabot siya ng korte. Before the complaint or information is filed, the person arrested may ask for a preliminary investigation in accordance with this rule, but he must sign a waiver of the provisions of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Later on, babasahin natin yung Revised Penal Code na yan. Notwithstanding the waiver, he may apply for bail and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. Section 7, Records. Ano ba yung mga records supporting the information or complaint? An information or complaint filed in court shall be supported by the affidavits and counter-affidavits of the parties and their witnesses together with the other supporting evidence and the resolution on the case. Yan yung simulain ng case file ng isang korte. Sa criminal case, yan nagsisimula yan. Record of preliminary investigation. The record of the preliminary investigation conducted by a prosecutor or other officers as may be authorized by law shall not form part of the record of the case. However, the court on its own initiative or on motion of any party may order the production of the record or any of its part when necessary in the resolution of the case or any incident therein, or when it is to be introduced as an evidence in the case by the requesting party. Section 8. Cases not requiring a preliminary investigation nor covered by the rule on summary procedure. Ang sabi, if filed with the prosecutor, babasahin natin, kapag daw final sa prosecutor, If the complaint is filed directly with the prosecutor involving an offense punishable by an imprisonment of less than 4 years, 2 months, and 1 day, the procedure outlined in Section 3A of this rule shall be observed. The prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. Kung final naman, if filed with the municipal trial court. If the complaint or information is filed with the municipal trial court or municipal circuit trial court for an offense covered by this section, the procedure in Section 3A of this rule shall be observed. If within 10 days after the filing of the complaint or information, the judge finds no probable cause after personally evaluating the evidence or after personally examining in writing and under oath the complaint and his witnesses in the form of searching, questions, and answers, he shall dismiss the same. He may, however, require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still finds no probable cause despite the additional evidence, he shall, within 10 days from its submission or expiration of said period, dismiss the case. When he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused had already been arrested and hold him for trial. O, pag na-arresto na raw yung isang tao, usually nasa mga presinto dyan sa gilid ng munisipyo, commitment order para ilipat siya. Okay, ilipat siya doon sa under the care of the BJMP. However, if the judge is satisfied that there is no necessity for placing the accused under custody, he may issue summons instead of a warrant of arrest. Rule 113, arrest. Okay, ito yung pag-aresto. Ano ba ibig sabihin ng aresto? Ng pag-arrest? Arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. Section 2, paano ginagawa ang arrest? How made? An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. Yung sumuko siya. No violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. Section 3, ano yung duty ng arresting officer? It shall be the duty of the officer executing the warrant to arrest the accused and to deliver him to the nearest police station or jail without unnecessary delay. Section 4, execution of warrant. The head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. In case of his failure to execute the warrant, he shall state the reasons therefor. Section 5. Arrest without warrant when lawful. A peace officer or a private person may be, without a warrant, arrest a person. O kailan lang ba pwedeng maging valid yung arrest without warrant? Kanina pinag-uusapan natin yan. Letter A. When in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Letter B. When an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it, and when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or is temporarily confined while his case or is pending, or has escaped while being transferred from one confinement to another. So yun lamang tatlo na yun ang basihan na pwede kang maaresto without warrant of arrest. 'Di ba? Pag nasa presence ng isang officer of the law, yung taong aarestuhin gumawa ng krimen, nagpaplanong gumawa ng krimen, o nakagawa na ng krimen. O letter B, meron ng isang krimen na nangyari at yung officer ay may probable cause to believe base sa kanyang personal na kaalaman na itong person na to yung gumawa nun. At pangatlo, kung tumakas. Alam na natin yun. In cases falling under paragraph A and B above, the person arrested without warrant shall be forthwith delivered to the nearest police station or jail and shall be proceeded against in accordance with Section 7 of Rule 112. Section 6, time of making arrest. An arrest may be made on any day and at any time of the day or night. Section 7, method of arrest by officer by virtue of warrant. When making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and of the fact that a warrant has been issued for his arrest, except when he flees or forcibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. The officer need not have the warrant in his possession at the time of the arrest, but after the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as practicable. Section 8, method of arrest by officer without warrant. Ito naman walang warrant. When making an arrest without a warrant, the officer shall inform the person to be arrested of his authority and the cause of the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, has escaped, flees, or forcibly resists before the officer has opportunity so to inform him, or when the giving of such information will imperil the arrest. Siyempre, pinoproteksyon din natin yung ating mga arresting officers, di ba? Section 9, method of arrest by private person. When making an arrest, a private person shall inform the person to be arrested of the intention to arrest him and cause of the arrest, unless the latter is engaged in the commission of an offense, is pursued immediately after its commission, or has escaped, flees, or forcibly resists before the person making the arrest has opportunity to so inform him, or when the giving of such information will imperil the arrest. So meron pong citizen's arrest. Ay, iba pala yun. Pero isang private person na inaaresto ang isang taong nakagawa ng kasalanan. No? Section 10, officer may summon assistance. An officer making a lawful arrest may orally summon as many persons as he deems necessary to assist him in effecting the arrest. Every person so summoned by an officer shall assist him in effecting the arrest when he can render such assistance without detriment to himself. So kapag tinawag kayo ng pulis, nagabayan nyo siya, tulungan nyo siya para hindi magkandaletse-letse, hindi ma-arrest yung isang akusado peacefully. Hindi po kayo pupunta ron para makibugbog. Hindi po kayo tutulong doon para abusuhin nyo naman yung inaaresto. Pero tulungan nyo lang yung pulis para hindi mapahamak yung pulis at hindi rin mapahamak kayo at hindi rin naman mabugbog yung abusado. Siyempre, depende rin sa krimen na ginawa niya. Kung, di ba, kung ikaw naman yung biktima, hindi mo naman mapipigil na. Section 11, right of officer to break into building or enclosure. An officer, in order to make an arrest either by virtue of a warrant or without warrant, as provided in Section 5, may break into any building or enclosure where the person to be arrested is or is reasonably believed to be, if he is refused admittance thereto after announcing his authority and purpose. So, yung kapitbahay pala namin dito, na anak ng isang namayapang judge, meron siya mga warrant of arrest, hindi ma-serve sa kanya, pwede pala na pumasok yung mga officer doon sa bahay niya, matapos nilang magpakilala at arestuhin siya doon. Pero hindi, takot. Pero pag ordinaryong tao lang, ginagawa nila ito. Goodness gracious. Ito mga binabasa ko po ngayon, ito yung criminal procedure doon sa rules of court, pero maaaring may mga bago na ring batas na nasusupersede niya na ito. So, pag meron, susubukan ko ilagay yung link dito o susubukan nating i-live ulit. Section 12. Saan na tayo? Right to break out from building or enclosure. Whenever an officer has entered the building or enclosure in accordance with the preceding section, he may break out therefrom when necessary to liberate himself. Ang keyword dito is necessary to liberate himself. Mamaya sinira-sira lang naman ng officer, siga-siga siya, mali naman yon. When necessary lang to liberate o pakawalan mo yung sarili mo. Arrest after escape or rescue. If a person lawfully arrested escapes or is rescued, any person may immediately pursue or retake him without a warrant at any time in any place within the Philippines. Section 14, right of attorney or relative to visit person arrested. Any member daw of the Philippine Bar, yung mga abogado po, linawin natin, lisensyadong abogado, shall, at the request of the person arrested or of another acting in his behalf, have the right to visit and confer privately with such person in the jail or any other place of custody at any hour of the day or night. Subject to reasonable regulations, a relative of the person arrested can also exercise the same right. Rule 114. Bail. O ano nga ba yung piyansa? Bail. Bail is the security given for the release of the person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions herein specified. Bail may be given in the form of corporate surety, property, bond, cash deposit, or recognizance. Alam niyo po, ang piyansa po, lagi natin iniisip dyan, temporary na kalayaan. Pero ito ay security sa halaga. May halagang itinakda na ilagak mo sa korte para masiguro na ikaw ay a-attend. At kapag ang kaso mo naman ay na-dismiss, pwede mong bawiin ang piyansa na ito. Ngayon, kung nagpiyansa ka, tapos tumakas ka, hindi ka na nag-attend ng hearing, at nahuli ka, tapos wala ka namang kasalanan pala sa huli, wala na, hindi mo na mababawi yung piyansa mo. O di naman, madaragdagan ka ng problema. So kapag nakapiyansa ka, sumunod ka, mag-attend ka ng hearing, mag-attend ka sa mga ipinag-uutos ng korte. Hindi yung piyansa ka tapos tatago ka. Mas mapapahamak ka lamang, di ba? Okay. Section 2, conditions of the bail. All kinds of bail are subject to the following conditions. Basahin natin letter A. The undertaking shall be effective upon approval and unless cancelled shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to it. Letter B. The accused shall appear before the proper court whenever required by the court of these rules. Yan, sinabi ko yan. Letter C. Failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such absence, the trial may be proceeded in absentia. Hindi ka makakapagpresenta ng sarili mong depensa. Letter D. The bondsman shall surrender the accused to the court for execution of final judgment. So yung bondsman mo, kailangan presenta ka sa korte. The original papers shall state the full name and address of the accused, the amount of the undertaking, and the conditions herein required. Photographs taken within the last 6 months showing the face, left and right. Ayan. Profiles of the accused must be attached to the bail. Section 3. No release or transfer except on court order or bail. No person under detention by legal process shall be released or transferred except upon order of the court or when he is admitted to bail. Okay? May ituloy natin yan. Wait lang ha. Okay, ipagpatuloy na natin section 4, bail a matter of right at yung exception. All persons in custody shall be admitted to bail as a matter of right, which with sufficient sureties or released on recognizance as prescribed by law or this rule. Letter A, before or after conviction by the Metropolitan Trial Court, Municipal Trial Court in cities or Municipal Circuit Trial Court, and B, before conviction by the trial court of an offense not punishable by death, wala tayong death ngayon, reclusion perpetua or life imprisonment. Section 5, bail when discretionary. Kailan ba nagiging discretionary lang? Nasa sa sariling discretion o desisyon lamang ng judge o ng court. Upon conviction by the regional trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. Na-convict na siya. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the appellate court. So, pwede ka palang magpiyansa pa rin. Kunwari, guilty ka. Sabi ng korte, guilty ka doon sa lower court, sa trial court. Pag umapila ka, doon ka pwede magpiyansa. However, nasabi, before matransmit yung record sa appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court. Okay. So, kung yung desisyon daw nung korte, dati non-bailable yung kaso mo, naging bailable, mas mababang offense ka dinesisyon ng korte, the application for bail daw can only be filed with and resolved dun sa nakatataas na hukuman. Okay? Hindi kagaya kanina, medyo nagkamali ako. The application daw for bail may be filed and acted upon by the trial court kahit na nakinonvict ka na nila bago nila mai-transmit yung records mo sa appellate court. Pero kung ang nangyari sa'yo is, kunwari, murder ang kaso mo, pero naibaba ang sentensya mo sa isang bailable na offense, yun yung desisyon ng trial court, yung appellate court na magre-resolve ng bail mo. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail subject to the consent of the bondsman. If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail. Ayan ang penalty ay 6 years, na mahigit sa 6 years, the accused shall be denied bail or his bail shall be cancelled upon a showing by the prosecution with notice to the accused of the following or other similar circumstances. So ito yung, kumbaga, hinaharang ng prosecution yung piyansa mo. Pero ino-notify ka rin naman nila. But ano yung mga grounds para harangin nila yung piyansa mo? Letter A, isa kang recidivist, quasi-recidivist or habitual delinquent, or has committed the crime aggravated by the circumstance of reiteration. Letter B, that he has previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid justification. Makulit ka pala. Letter C, that he committed the offense while under probation, parole, or conditional pardon. Sus Mariosep. Letter D, that the circumstances of his case indicated the probability of flight if released on bail. Tatakas ka. And letter E, that there is undue risk that he may commit another crime during the pendency of the appeal. So, pag ganon ang grounds na pinakita ng isang prosecutor, naku po, hindi ka makapagpiyansa. Tapos ang penalty ng krimen mo, higit sa 6 years. So, baka hindi ka payagang magpiyansa ng korte. The appellate court may motu proprio or on motion on any party review the resolution of the regional trial court after notice to the adverse party in either case. Section 6. Capital offense defined. Ano ba yung mga capital offenses? A capital offense is an offense which under the law existing at the time of its commission and of the application for admission to bail may be punished with death. Siguro nabago na yung definition nito ngayon kasi walang death. Reclusion perpetua to life. Yun siguro yun. Masasabi mong capital punishment like murder. Yan. Yung rape na may murder pa, may rape with homicide, mga ganyan. O yung pagtutulak ng droga, sus Mariosep, yan. Section C. Capital offense of an offense punishable by reclusion perpetua or life imprisonment not bailable. No person thou charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Section 8. Burden of proof in bail application. At the hearing, didinggin po kasi ang application for bail eh. Lalo na kapag medyo mataas ang punishment sa krimen na iniaakusa sa'yo. At the hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment, the prosecution has the burden to show that evidence of guilt is strong. The evidence presented during the bail hearing shall be considered automatically reproduced at the trial, but upon motion of either party, the court may recall any witness for additional examination unless the latter is dead, outside of the Philippines, or otherwise unable to testify. Letter 9. Amount of bail at yung guidelines. The judge who issued the warrant or granted the application shall fix a reasonable amount of bail, considering primarily but not limited to the following factors. Letter A. Financial ability of the accused to give bail. Letter B. Nature and circumstances of the offense. C. Penalty for the offense charged. D. Character and reputation of the accused. E. Age and health of the accused. F. Weight of the evidence against the accused. G. Probability of the accused appearing at the trial. H. Forfeiture of other bail. I. The fact that accused was a fugitive from justice when arrested. And letter J. Pendency of other cases where the accused is on bail. Excessive bail shall not be required. Kaya siguro umuobra yung mga motion to reduce bail para naman makapagbayad. Hindi masyado mahirapan yung pamilya ng akusado. Section 10. Corporate surety. Any domestic or foreign corporation licensed as a surety in accordance with law and currently authorized to act as such may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. Hindi ko lang alam. Siguro ito mga to, may mga may collateral na hinihingi ito mga corporate surety. Kaya tuwang-tuwa ito pag may mga kriminal ito mga corporate surety. Section 11, property bond and how posted. A property bond is an undertaking constituted as lien on the real property given as security for the amount of the bail. So, pwedeng mga titulo. May kilala ako na nakulong na tao dahil sa drugs. Ang naging piyansa niya ay titulo ng lupa. Within 10 days after the approval of the bond, the accused shall cause the annotation of the lien on the certificate of title on file with the registration of deeds if the land is registered, or if unregistered, in the registration book on the space provided therefor, in the registry of deeds for the province or city where the land lies, and on the corresponding tax declaration in the office of the provincial, city, and municipal assessor concerned. Within the same period, the accused shall submit to the court his compliance, and his failure to do so shall be sufficient cause for the cancellation of the property bond and his rearrest and detention. Section 12. Qualifications of sureties in bonds. Qualification of sureties in property bond. Sino ba yung pwede maging surety ng property bond? Letter A, each must be a resident owner of real estate within the Philippines. Letter B, where there is only one surety, his real estate must be worth at least the amount of the undertaking. Letter C, if there are two or more sureties, each may justify in an amount less than that expressed in the undertaking, but the aggregate of the justified sums must be equivalent to the whole amount of bail demanded. So kapag yung basta yung lote mo na gagawin mong bond pangpapiyansa mo, kailangan ah, kasing halaga ng piyansa mo, higit pa. In all cases, every surety must be worth the amount specified in his own undertaking, over and above all just debts, obligations, and properties exempt from execution. Section 13. Justification of sureties. Every surety shall justify by affidavit taken before the judge that he possesses the qualifications prescribed in the preceding section. He shall describe the property given as security, stating the nature of his title, its encumbrances, the number and amount of other bails entered into by him and still undischarged, and his other liabilities. The court may examine the sureties upon oath concerning their sufficiency in such manner as it may deem proper. No bail shall be approved unless the surety is qualified. Section 14. Deposited of cash as bail. The accused or any person acting in his behalf may deposit in cash with the nearest collector or internal revenue internal revenue or provincial, city or municipal treasurer the amount of bail fixed by the court or recommended by the prosecutor who investigated or filed the case. Upon submission of a proper certificate of deposit and a written undertaking showing compliance with the requirements of Section 2 of this rule, the accused shall be discharged from custody. The money deposited shall be considered as bail and applied to the payment of fine and costs, while the excess, if any, shall be returned to the accused or to whoever made the deposit. Ano naman yung recognizance? Whenever allowed by law or these rules, the court may release a person in custody to his own recognizance or that of a responsible person. Usually, yung mga abogado ito, nire-recognize ng abogado. Section 16, bail when not required. Reduced bail or recognizance. No bail shall be required when the law or these rules so provide. When a person has been in custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charged, he shall be released immediately without prejudice to the continuation of the trial or the proceedings on appeal. If the maximum penalty to which the accused may be sentenced is distierro, he shall be released after 30 days of preventive imprisonment. A person in custody for a period equal to or more than the minimum of the principal penalty prescribed for the offense charged, without application of the indeterminate sentence law or any modifying circumstance, shall be released on a reduced bail or on his own recognizance at the discretion of the court. Okay? Yang indeterminate sentence law na yan, ano yan? Kasama yan sa pagbibigay ng desisyon sa korte do sa penalties. Section 17, bail where fixed. Letter A. Bail in the amount fixed may be filed with the court where the case is pending or in the absence or unavailability of the judge thereof with any regional trial judge, metropolitan trial judge, municipal trial judge, or municipal circuit trial judge in the province, city, or municipality. If the accused is arrested in a province, city, or municipality other than where the case is pending, bail may be filed with any regional trial court or of said place, or if no judge thereof is available, with any metropolitan judge, municipal trial judge, or municipal circuit trial judge therein. Letter B. Where the grant of bail is a matter of discretion or the accused seeks to be released on recognizance, the application may be filed only in the court where the case is pending on trial or appeal. Letter C. Any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held. Section 18, Notice of Application to the Prosecutor. In the application for bail under Section 8 of this rule, the court must give reasonable notice of the hearing to the prosecutor or require him to submit his recommendation. Dahil sa korte may nakalagay yan, recommended bail. Yan, may ganon. May recommended na amount ng bail yung prosecutor. Release on bail. The accused must be discharged upon approval of the bail by the judge with whom it was filed in accordance with Section 17 of this rule. Whenever bail is filed with the court other than where the case is pending, the judge who accepted the bail shall forward it together with the order of release and other supporting papers to the court where the case is pending, which may, for good reason, require a different one to be filed. Ito yung nabanggit ko kanina, increase or reduction of bail. After the accused is admitted to bail, the court may, upon good cause, either increase or reduce its amount. Kaya merong motion to reduce bail. When increased, the accused may be committed to custody if he does not give bail in the increased amount within a reasonable period. An accused held to answer a criminal charge who is released without bail upon filing of the complaint or information may, at any subsequent stage of the proceedings and whenever a strong showing of guilt appears to the court, be required to give bail in the amount fixed or in lieu thereof committed to custody. Section 21, forfeiture of bond. O yung, ito siguro yung yung na-forfeit, yung karapatan mong bawiin, yung piyansa mo. When the presence of the accused is required by the court or these rules, his bondsman shall be notified to produce him before the court on a given date and time. Yun ay kung bondsman ang nagpiyansa sa'yo. If the accused fails to appear in person as required, his bail shall be declared forfeited and the bondsman given 30 days within which to produce their principal and to show cause why no judgment should be rendered against them for the amount of their bail. Within the said period, the bondsman must, letter A, produce the body of their principal or give the reason for his non-production, and letter B, explain why the accused did not appear before the court when first required to do so. Failing in these two requisites, a judgment shall be rendered against the bondsman jointly and severally for the amount of the bail. Sila talaga yung sisingilin ng kabuoang piyansa nila. The court shall not reduce or otherwise mitigate the liability of the bondsman unless the accused has been surrendered or is acquitted. Section 22, cancellation of bail. Upon application of the bondsman with due notice to the prosecutor, the bail may be cancelled upon surrender of the accused or proof of his death. Na mayapa na kunwaring isang akusadong under bail. Kailangan may pruweba yon. The bail shall be deemed automatically cancelled upon acquittal of the accused, napawalang sala siya, dismissal of the case, or execution of the judgment of conviction. Pag na-convict yung isang hindi mo na mababawi yung bail mo. In all instances, the cancellation shall be without prejudice to any liability on the bond. Section 23, arrest of accused out on bail. For the purpose of surrendering the accused, the bondsman may arrest him or upon written authority endorsed on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of suitable age and discretion. An accused released on bail may be re-arrested without the necessity of a warrant if he attempts to depart from the Philippines without permission of the court where the case is pending. Section 24. No bail shall be allowed after the judgment of the conviction has become final. If before such finality, the accused has applied, parang mali yung grammar niya rito, has applies, the accused applies for probation, he may be allowed temporary liberty under his bail kung nag-apply daw siya ng probation. When no bail was filed or the accused is incapable of filing one, the court may allow his release on recognizance to the custody of a responsible member of the community. In no case shall bail be allowed after the accused has commenced to serve sentence. Pagka nagsiserve na ng sentensya ang isang akusado, hindi na siya pwedeng piyansahan. Section 25, Court Supervision of Detainees. The court shall exercise supervision over all persons in custody for the purpose of eliminating unnecessary detention. The executive judges of the RTCs, regional trial courts, shall conduct monthly personal inspections of provincial, city, and municipal jails and their prisoners within their respective jurisdictions. They shall ascertain the number of detainees, inquire on their proper accommodation and health, and examine the condition of the jail facilities. Sana nga, no? Parang di naman. They shall order the segregation of sexes and of minors from adults, ensure the observance of the right of detainees to confer privately with counsel, and strive to eliminate conditions inimical to the detainees. In cities and municipalities to be specified by the Supreme Court, the municipal trial judges or municipal circuit trial judges shall conduct monthly personal inspections of the municipal jails in their... Hindi natin alam to, wag na natin basahin tong mga dapat ginagawa raw ng judge. Baka may bago na. Hindi naman na nila ginagawa yata yan. Bail not a bar to objections on illegal arrest, lack of or irregular preliminary investigation. An application for or admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefor, or from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided that he raises them before entering his plea. The court shall resolve the matter as early as practicable but not later than the start of the trial of the case. Magtungo na tayo sa Rule 115, Rights of the Accused. Ito yung karapatang nakaangklas sa Bill of Rights ng ating Konstitusyon. Section 1. In all criminal prosecutions, the accused shall be entitled to the following rights. Letter A. To be presumed innocent until the contrary is proved beyond reasonable doubt. Letter B. Beyond reasonable doubt. Yung walang katiting na doubt na sinisiguro mo na siya nga talaga ang gumawa ng krimen. Letter B. To be informed of the nature and cause of the accusation against him. Ito yung ipinapaalam. Huhulihin pa lang yung tao, may Miranda rights na, nire-recite ito ng mga police. You have the right to remain silent. Anything you say or do can be filed against you. You have a right to an attorney. If you cannot provide for your own attorney, the state will provide one for you. Yan yung Miranda rights. At di ba sa atin, dinadala sa piskal, dinadala pa yan pag inquest. Dadalhin pa yan sa PAO, Public Attorney's Office, para may paliwanag sa kanila yung kalagayan nila. Letter C. To be present and defend in person and by counsel at every stage of the proceedings, from arraignment to promulgation of judgment. Karapatan niya na nakaangkla sa ating konstitusyon. So kahit po anong galit natin sa isang akusado na tingin natin na sama nito, demonyo to, siya po ay inosente until proven guilty beyond reasonable doubt, at hindi tayo pwedeng magalit kasi duty ng isang abogado. Hindi natin pwedeng i-generalize na salbahe yung mga lawyer na yan, yung lawyer ni Ampatuan kunwari, hindi, duty niya na i-represent ang isang akusado kahit nagaano pa man ito kasama sa tingin natin. Yung mga gagawin niya, kung illegal man ang gagawin niya o masama, nasa kanila na ng Panginoong Jesucristo yun, o ng Panginoon, bahala ka na kung gagawa ka na masama. Pero as far as representing an accused, it is the sworn duty ng mga abogado. The accused may, however, waive his presence at the trial pursuant to the stipulations set forth in his bail, unless his presence is specifically ordered by the court for purposes of identification. The absence of the accused without justifiable cause at the trial of which he had notice shall be considered a waiver of his right to be present thereat. When an accused under custody escapes, he shall be deemed to have waived his right to be present on all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his right without the assistance of the counsel. Pero parang wala namang ganyan. Ang alam ko lang na ganyan si Marcos, si former President Marcos. Letter D, to testify as a witness in his own behalf but subject to cross-examination on matters covered by direct examination. His silence shall not in any manner prejudice him. Letter E, to be exempt from being compelled to be a witness against himself. Kaya nga bawal yung anti-torture law na bubugbugin mo, umamin ka na! Diba? Kukuryente mo yung mga bayag. Bawal yun, kaya gugupitin mo yung daliri. Letter F, to confront and cross-examine the witness against him at trial. Either party may utilize as part of its evidence the testimony of a witness who is deceased, out of or cannot with due diligence be found in the Philippines, unavailable or otherwise unable to testify, given in another case or proceeding, judicial or administrative, involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him. Letter G, to have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. So karapatan niya ng akusado na padalhan ng mga process para maka-attend siya sa hearing at maiproduce yung mga ebidensya in his behalf. Letter H, to have speedy, impartial, and public trial. Speedy, mabilis sa paglilitis. Impartial, walang kinikilingan. And public trial on open court. Trial in open court. Nalilito na ako sa grammar, ano. And letter I, karapatan ng isang akusado, it is the right of the accused to appeal in all cases allowed in the manner prescribed by law. So sana po ay may natutunan tayong lahat ngayon sa aking pagbabasa ng Criminal Procedure Rule 110 to 115 hanggang Rule 127 pa ito. Sana po ay samahan niyo ako muli sa aking pagbabasa ng mga batas. Susubukan ko itong ipaliwanag para maintindihan nating lahat ng mga ordinaryong tao in layman's terms. Good night.